Hello and welcome to Rent Stabilization 101. This is going to be a landlord-focused webinar where we go over the basics of rent stabilization in Mountain View, mainly focused on apartment rent stabilization, the Community Stabilization and Fair Rent Act, also known as the CSFRA. But we'll also be giving some details about the Mobile Home Rent Stabilization Ordinance, which is the MHRSO. So we'll be talking about both of those. And today is June 26, 2025. Let's go ahead and get started. And just before I start, actually, let's have a quick reminder that city staff is not able to offer any type of legal advice, but I will be giving facts, best practices, and an overview of the CSFRA, MHRSO, and we'll also talk about a couple other California state laws as well. So my name is Andrea Kennedy, and I work in the housing department, and more specifically in the rent stabilization division. So the first thing we'll talk about today is rent stabilization coverage. Who is covered under these laws? So for both the CSFRA, the apartment rent stabilization, and mobile home rent stabilization, it's meant to stabilize communities by reducing housing turnover in certain types of rental units. And so our laws do that in three main ways. First, by stabilizing rent. And what I mean when I say that is that there are rent limits, rent caps every year on how much you as the landlord can increase your tenant's rent. And we'll get a little bit more into all of these as we go along. The second main provision under rent stabilization is providing eviction protections. So there are only a certain number of reasons, certain allowed reasons that a tenant can be asked to vacate their unit. And then thirdly, the rent stabilization is meant to ensure a fair rate of return on a property owner's investment in their rental property. So if they're not making a fair rate of return, there is a process in which they can petition the city to increase rents on their tenants. And we'll talk about that a little bit more. So what types of homes are covered? So when we talk about apartment rentals, we're going to be talking specifically about the CSFRA, or the Community Stabilization and Fair Rent Act. And this covers most of our apartment buildings in Mountain View that have 3 or more rental units on them. So if you live in an apartment building with 3 or more units, you're most likely covered. If you're not sure if you own, in this case, if you own an apartment complex with 3 or more units, your property is probably covered. However, we can double check that for you, of course, because there are some interesting exceptions to these rules. And there's 2 different types of coverage in Mountain View. So we have the properties that are fully covered, and then we also have properties that are partially covered. So our fully covered rental properties are going to be those that were built before 1995. And both of our rent stabilization provision and the just cause eviction protection provisions will apply to those fully covered units. And then we have a handful of properties that are only partially covered. And for those, they're built between 1995 and 2017 when the law went into effect. And for those ones, only the eviction protections part of the law applies. There is no rent stabilization, rent limits for partially covered units. And then when we're looking at our mobile homes in Mountain View, we have 6 mobile home parks, and they all have mobile home rent stabilization. So there's sort of 2 types of rent stabilization when we're looking at mobile homes. We're looking at mobile home owners who own the actual home and they're renting the space as well as any communal facilities, like a pool or a community hall or something like that. They're renting the space in the community areas from the mobile home park owner. So those rented portions are going to be covered by the rent stabilization ordinance. And then we're looking at mobile home renters who actually are renting the home and the space and the community area. They're renting all of it from a mobile home landlord. So the landlord who owns that mobile home. And then those sort of rent protections, and for them, the just cause eviction protections apply there. So there's apartment rent stabilization as well as mobile home rent stabilization in Mountain View. So we do have some exemptions for our apartment rentals. So single family homes that are on their own lot or on their own parcel, those are exempt. Condominiums are exempt. Companion units are exempt. So if you've gone to the city and you have a permit for an ADU, for example, that might be exempt. Any duplexes that are on your property, those are also going to be exempt. So if you're a landlord and you have, say, a property that has a duplex and a triplex on it, the triplex would be covered, the duplex would be exempt. So again, some configurations can be a little bit confusing, but we can help you through that if you have questions. Additional exemptions when we're talking about apartment rentals, anything, hotels, motels, short-term rentals, those are also exempt, hospital care facilities, and then any government subsidized rental units. And by that, we mean an actual subsidized low income apartment building where all of the units are government subsidized. We don't mean Section 8 where tenants are paying with a voucher. Section 8 is still covered. As well as any below market rate units that fall under, built before 1995 or partially covered, built between 1995 and 2017, those would still be covered as well. So we can help you if you have any questions with that. All right, and now we're sort of going to go through and talk about each of the main components of these rent stabilization laws. So we're just going to break them down by section so you get a nice overview of, what the law is, what you should be paying attention to, what your responsibilities are as a landlord, and then, what some of the responsibilities might be for your tenants. So we'll start out with rent and security deposits. And so when we're talking about what's included in rent, specifically for apartment rentals underneath the CSFRA, we want to look at base rent. So that's sort of where it all begins, your base rent, and then, you increase from that point. So the base rent is the initial rent at move-in, and this should include any fees and utilities. So parking fees, pet fees, water, sewer, garbage, storage fees, any other sort of housing services that you might be providing, that should all be included in the definition of rent, what you're charging as rent for the tenant. And then once you know what your base rent is, you can increase it from there as long as we follow the rules. And that the allowed rent increases would be our annual general adjustment, so that once a year rent increase percentage that you're allowed. For short, we call that the AGA. And then other ways to lawfully increase rent would be through the petition process or through banked rent increases. And then security deposits or any sort of deposits are actually not included in rent. So we don't consider them part of a tenant's rent, and that's because they can never be increased during the tenancy. So if you have your, security deposit in the beginning, if you have a pet deposit, That deposit is just held there, and it's not considered part of the increase when we're calculating our increase percentages. It just has to stay the same there. And so, as I'm sure you know, at the end of the tenancy, you use these security deposits to deduct any, unpaid rent or any damages, any cleaning fees from the property at that time. Now, one thing I do want to mention when we're talking about rent, because this question does come up a lot, when we're looking at these additional fees or services that a property might offer, but the tenant maybe doesn't want to take advantage of them right when they move in. We see this a lot with maybe a pet fee. The tenant might not have a pet when they move in, but they want a pet, maybe a year in or so. And usually there might be another fee or a deposit on that, or maybe they want an additional parking space or an additional storage space. To avoid a petition process that allows the landlord and the tenant to agree mutually to increase rent, one way to do this is when you're signing a lease with your tenant to have sort of a menu or an addendum at the back of the lease or somewhere in the lease that has the service and then the cost of that service. So, if at any time they want to add in a storage $50 per month fee, and then they can opt into that. As long as it's very clearly stated in the lease, they can opt into that and it won't cause any problems. And then they'll just add that amount on, and that will be all considered part of their rent. And then moving forward, any rent increases would be based off of that new amount. So that's just sort of something to keep in mind. I know a lot of our landlords have been updating their lease templates because of that. So you can definitely come and ask us if you have any questions about that. Okay, and so I also wanted to talk a little bit about this semi-new state law, AB 12, that went into effect July 1st, 2024, and it's about security deposits specifically. So in California, in most cases, security deposits are limited to 1 month's rent. However, in certain cases, a landlord would be able to charge 2 times rent if both of the following are true. The landlord is a natural person or LLC, in which all members are natural people. And 2, the landlord owns no more than 2 residential rental properties, each containing no more than 4 units. So if both of those are true, a landlord can charge up to 2 months of a security deposit. So that's just something to keep in mind as well. There we go. All right, now let's dive into rent increases. So rent increases, again, there are certain restraints around how much and when landlords are able to increase rent for their tenants. So the main one is that at least 12 months have passed since the tenant's previous rent increase. So essentially it's 1 rent increase per year, 1 rent increase per 12-month period. A landlord also has to be in compliance with the law in order to increase rent. So that includes paying the annual fees, registering the property, and being sort of generally in compliance with other provisions. So that includes code violation, not having any code violations, the building should be habitable and safe. And then of course, as far as noticing goes, the landlord does need to serve a written notice 30 days to the tenant in order to increase their rent. So looking forward, our 2025 allowed rent increase, or our annual general adjustment, the AGA, is going to be 2.7%, and that goes into effect September 1st of this year, 2025. You may or may not have already used your 2024 rent increase of 2.4%, but you'll see here sort of a list of the previous year's rent increases. And then I will also mention here, there has been a change in the way that the mobile home rent increases are calculated. So up until 2024, they followed the same amounts as apartment rent increases, but for 2025, starting September 1st, they're going to be calculated differently. And that's because they're now limited to 60% of CPI, whereas apartment rent increases 100% CPI, so this is a little bit less. And there's a maximum of 3% increase. So if the CPI goes over 3%, it will be limited and capped at 3%. So for 2025, you'll see it's 1.6%. It's a little different there. Okay, another thing about our rent increases is that we have a thing called banked rent increases, where if a landlord decides for whatever reason that they're not going to apply one of the allowed rent increases for that year, they can save it, put it in the bank, if you will, and then they can pull that out at another year and combine those rent increases together. So if a landlord is using a current rent increase along with a banked rent increase, it is capped at a total of 10%. So you can't go over 10% a year. If you have more than 10% banked, you would have to sort of split that up into a couple years of using banked rent increases. And we did see this a lot, especially during COVID, where landlords were holding off on rent increases sort of during 2020, 2021, 2022. So some people ended up with, 12% banked rent increases that they had to split up over a couple years. So just know that that is something that is possible. However, banked rent increases do not carry over from one owner to another. So if you sell the property, the new owner does not get those rent increases. They sort of get lost. And the new owner has to start over. But it's good to know. And another big topic that we are working through right now, so I wanted to make sure I mentioned it, is utilities. So as I previously stated when we were looking at what all should be included in rent, utilities is something that should be included in rent. However, in Mountain View, not all of our apartments are sub-metered. So there are some properties, and we're looking specifically when I'm talking about this, about fully covered place. A lot of people are using con service or some similar type of service to, divide up that big utility bill. Now, because the CSFRA specifically says utilities should be included in rent, we needed to create a process where we can wrap tenants' utilities into their rent, but also allow for landlords not to sort of lose out on, capturing that money for those costs. So we're currently having a one-time utility adjustment petition process that's going on. And it started early 2024. So for new tenancies that started March 1, 2024, the RUBS, the ratio utility billing systems, are no longer allowed. So for those new tenants, their total rent must include utilities. And when you're writing that out in your lease, you must state the total rent amount and then specify the types of utilities and housing services that are included in that. So if it includes water, garbage, sewer, parking, pet fees, you want to just be explicit about what is all included in that tenant's rent. Excuse me. Okay. And then for existing tenancies that you already had before March 1st, 2024, you're going to continue using RUBS. So if you're using Conservice, you continue to do that until you have completed your utility adjustment petition with the city. And if you have more questions and you need a little bit more guidance about how that all works, you can read about it in CSFRA Regulation Chapter 13, or join us in one of our webinars. The next webinar will be, I think, in August, and I'll have that date for you a little bit later. But another thing to keep in mind for those existing tenants, the utility charges for any new vacancies or newly rented units should not be allocated to the existing rental units through those RUB systems. And then any utilities that are paid directly by a tenant to a utility service provider, the main one being, PG&E, or if their utilities are actually sub-metered, so the tenant knows exactly how much their usage is and they're only paying for their usage, those types of utility charges are exempt and you wouldn't have to go through this process for it, but you would still need to notify the city that all of your utilities are sub-metered, or all of your utilities are already included in the rent. So you still want to make sure you contact and communicate with our office for that. Okay, and there has been an update about the petition submission deadline, so I wanted to make sure that I mentioned that here. So the deadlines have been extended. If you are the landlord of, 21 or more unit apartment building, your deadline has come and gone. It was due April 30th, 2025. But we have made contact with all of those properties, so everybody is in good shape there. So our next bunch is the 6 through 20 unit properties, and your petition deadline is extended to September 30th, 2025. So you have a couple more months to get your petition done and to work with staff. And then for our smaller landlords, that deadline is extended to December 31st, 2025. So just be aware of those new dates. We will definitely be communicating a lot about that throughout the next half a year. Okay, so of course, just cause eviction protections and eviction reasons are a big part of our rent stabilization law. So we'll look next at limitations on evictions. So as I mentioned before, the CSFRA and for those mobile home renters, there are 9 specific just cause reasons that you as the landlord are able to terminate a tenant. And we sort of like to break these down into 2 categories. One is tenant caused reasons, and the other would be more the landlord initiated reasons. So under the tenant caused reasons, we have 5, most common being failure to pay rent. Next, breach of lease, nuisance, criminal activity, and failure to give access to the landlord after being provided proper notice. So those are the tenant caused reasons, and you'll notice the 2 through 5 have an asterisk next to them. For those reasons, a landlord must first provide a notice to cease to the tenant and be very specific about how they violated, for example, the lease, when did it happen, how long they have to correct the issue. Maybe they're hoarding on the balcony or something. You give them a time frame to correct the issue. If it's not done by then you can issue them the formal termination notice. And moving over to our landlord cause or landlord initiated reasons, we have repairs or repairs that cause temporary vacancy, and that vacancy would be of a time of over 30 days. So if there has been some sort of structural damage or any other kind of damage to the property and the tenant is required to move out for more than 30 days, this reason would apply. We also have owner move-in, just cause eviction reasons, withdrawing the unit from the rental market, and demolition. And for all of these reasons, the landlord must be required to offer tenant relocation assistance to the tenants if they income qualify for that assistance. And that is a process that the city will help walk through with you. Now, for our mobile home owners, they are covered by state law, the mobile home residency law, and that provides its own set of eviction protections for mobile home owners. And so they have similar but different eviction causes. So again, failure to pay rent, violation of park rules and regulations, so similar to breach of lease, substantial annoyance, very similar to nuisance, non-compliance with state or local laws and regulations related to mobile homes, if a park is condemned, or if a part of the park is a change of use. So the whole park or part of the park changes its use from mobile home to something else. Okay, so now for eviction. So of course you start off with the termination notice. If the tenant then does not leave within the required the vacate date on the termination notice, the only way to get the tenant to move out of the unit is to go through the court process, to go through the eviction process. So you'll see, it starts with the tenant termination notice, which a copy of that does need to be sent to our office. And then again, if the tenant doesn't leave, the landlord would serve unlawful detainer paperwork to the tenant. The tenant has an opportunity to provide an answer to that claim to the courts. If they choose not to provide an answer, then the court would go straight to a judgment. However, if they do provide an answer to that, a court date would be set, and then the landlord and the tenant would go through to the eviction court. Ours is in San Jose, the Santa Clara County Court. And then the judge would make a judgment on that case. If the judge rules that the tenant is, say, not a violation of whatever the claim was, the tenant can stay in their unit. If the judgment is against the tenant, of course, the tenant would then need to move out, and the sheriff would then go and post that those eviction notices on that tenant's property. So that formal court process is the only way to evict a tenant from their unit. There are no constructive evictions allowed in the state of California. So constructive evictions are any specific action taken so that the tenant can't come into their unit, or that the condition of the unit is so bad that the tenant has to leave. So no changing the locks on the tenant. It can't cut off the utilities to their unit or harass them. Physically preventing them from entering, which if you were reading the newspaper a couple of years ago, there was a case of that where the property owner was physically covering the door so the tenants could not go into their unit. That's not allowed. And then any unaddressed habitability issues, which just render the unit unusable, unsafe, that's not allowed either. It has to be through the courts. Alrighty. So we'll look next at responsibilities in the unit. So what is the landlord responsible for? What is the tenant responsible for? So generally speaking, landlords are responsible for providing the rental unit in a habitable condition. And there are more specifics, more details about what is considered habitable, but having working plumbing and gas, having heating and electricity to the unit, having roof and exterior walls that are in good condition, that are safe, that are not leaking, not broken, things like that. There should be no vermin, no garbage buildup in or around the premises, and the windows and doors should be locking. So the public facing windows and doors, anything from the outside. And then your tenants also have responsibilities to take care of the units that they're renting. So they are responsible to take care of their specific unit as well as the common areas. And if there is something that has gone wrong or is broken, it is their responsibility to inform you as the landlord or the property manager as soon as possible so that you have the opportunity to correct it. And then, of course, if they cause any damage or their guests, children, or pets cause any damage, they then are responsible to fix it or pay for it. So if, excuse me, if the tenant causes the damage and they don't fix it, you as the landlord still are responsible for the repair of the damage. However, you would then charge that back to the tenant because you still want to make sure that the unit is habitable. But if they cause that, then they would be responsible for that. And of course, everything in writing and receipts and paperwork is your best friend. Okay, so looking just sort of at responsibilities of rental units. As a landlord, when you are in the process of renting out your unit, you want to be very cognizant of fair housing laws and fair housing discrimination laws. So anything that is sort of arbitrary cannot be used as a reason for you to not rent to a tenant or a household. So that would include, things that are outside of their control. You shouldn't be looking at, race or color or religion, familial or marital statuses, national origin, what is their primary language spoken, immigration status. You don't want to look at sex, sexual orientation, gender identity, or if they have a disability or at their age. So those are things they can't control. And then additionally, you're not allowed to be judging off of the tenant or the household source of income, how they make their money. They just need to meet the income qualifications. And in that same sort of vein, we'll look at who is allowed to live in units because we have specific regulations about family members and roommates. So when they sign the lease, you have those people on the lease, that they also may be able to bring in certain people. So they can bring in eligible family members into their unit, even if they maybe were not on the original lease. So that would be really immediate families if they had, a child, or that would be sisters, brothers, parents. So it's really limited. But there is also a form that the tenant would have to give you to notify you of this. And as the landlord, you are able to request reasonable documentation to prove these familial relationships. Secondly, replacement roommates are allowed. They do have to notify you as a landlord again, and the landlord may perform any tenant screenings. But this would be a situation where, for example, there's two roommates that move in, one roommate moves out, and the roommate that's still living there needs to replace that roommate that moved out to still afford the rent. So they can do a 1-for-1 replacement. And everything in the unit would still kind of stay the same. The rent increases, everything to stay the same. Only in cases where all of the original occupants moved out and it's only replacement roommates left, then you can sort of readjust and bring the rent up to market. But otherwise, the rent would stay the same and follow the same rules. And in these cases, since it is, a replacement roommate and they are probably going to be responsible for some of the rent, the landlord can do the appropriate credit checks and background check documentation that they need to. Okay, and so finally, subletting and added roommates, not 1-for-1 replacement, but additional roommates, is only allowed as the lease allows it. So if the lease says that it's allowed, it can be allowed. If the lease says it's not allowed, then it's not allowed. And if there are any subtenants or additional roommates, the main leaseholder is not able to charge the subtenants in excess of what you, the landlord, are charging them for that unit. So they can't use it as a money-making situation. It's just they can only charge up to what is allowed under the lease. So those situations come up often, so it's good to just kind of have that information in your back pocket. Alrighty, so another big part of our program are petitions, and for property owners, this is how we can raise rent above what's allowed each year, and for tenants, they can request a downward adjustment of their rent. So for what we call an upward adjustment of rent, or again, what I was kind of saying, rent increases that are above the annual allowed percentages, there are a couple of options. First, we have that landlord petition where if you're not making a reasonable rate or a fair and reasonable rate of return on your property, you can file a petition for that, and our staff can sort of help walk you through that if you're interested. And there are also joint petitions. Again, we talked a little bit about this earlier, but that is between both the landlord and the tenant. It needs to be initiated by the tenant. But basically, both people are on board. They're saying, yes, we want a new housing service or some type of modification, and we're willing to pay a little bit more. And then to be aware of our tenant petitions, because if a tenant files a petition for downward adjustment of their rent, they are going to serve it on you as the landlord. And so their main reasons would be if they believe that unlawful rent is being collected, if they feel that the property is failing to maintain habitable premise, if there has been some sort of decrease in housing services or maintenance. So we've seen that with the removal of a pool, the removal of laundry facilities, or the failure to maintain laundry facilities, things like that. They can request an adjustment downward of their rent. And then for certain types of rent increases, like a banked rent increase or a landlord petition increase that's going to increase the rent above that allowed percentage for the year. A tenant can file a hardship petition. They have to meet specific criteria, income, age, disability, things like that, criteria to say that. And this increase that is above what's allowed for that year is going to cause an undue hardship on them. So those are sort of the tenant petition options. So just to be aware of those. And another really big part of this law, especially for landlords, so I wanted to at least add it into this workshop, is compliance. Because any property owner who fails to substantially comply with the law or the regulations is not able to legally raise their rent. And if you do raise your rent and you're not substantially compliant, and a tenant files a petition of unlawful rent, it could cause a lot of unwanted challenges. So we want to try to avoid that as much as we can. So when we're talking about substantial compliance, we're not talking about every little detail. We're just talking sort of about the big bucket items. So when the law first passed, there was a rollback that was required for any tenants that were in the unit, already before October 19th, 2015, or if their rent should be sort of rolled back to that amount that they were paying on that date. So if that didn't happen, please get in contact with us so we can kind of take a look at it. And then the other thing, obviously, we want to make sure that we're following those annual allowed rent percentages each year, and staying within the allowed rent increases. So our rent has to be correct in order to move forward increasing rent. So we have to be in compliance with that. Another big thing is to pay our annual rental housing fees or our annual mobile home space fees. We want to do that, and we want to do that in a timely manner to avoid any late penalties. Similarly, we want to make sure that we're registering our property every year before January 31st. So we're in compliance with that requirement as well. And then finally, we need to make sure that our properties are habitable and up to code. They don't have any outstanding code violations or are violating any sort of health and safety laws. So those are the big 5 items to make sure that your property is in substantial compliance. If you check off all those boxes, then you can go ahead and raise your rent without any worries. So in the case that you might be out of compliance with one of those things, again, as I was saying, you're not able to increase your rent until that's all corrected. If you did increase your rent during that time, you would need to refund any overpayments of rent while the property was out of compliance. If the city is aware that you may be in violation of one of these things, they can send you a notice. So it's just a letter directly to the landlord. And if the property is still out of compliance after 30 days of receiving that notice, a second notice goes out to the landlord. However, this time a copy is sent to any affected tenants. So at this point, the tenants will be notified that the property is out of compliance. And if they received any unlawful rent increases, they could potentially file a petition. And so there are also late fees for failing to pay the rental housing fee before January or by January 31st. And that is 4% per month per outstanding balance. So that adds up pretty quickly. And our registration late penalty also adds up really quickly. It's $25 per unit per month. So please be aware of that. And if you think maybe you are out of compliance with one of these things, reach out to our office and we can help you get back in compliance. Right, and then just before we wrap up, I wanted to go over some of the new state laws that just passed. So we already talked about that security deposit one earlier, so I won't go ahead and talk about it here. But AB 2801 is going into effect. So some of it went into effect already and some of it's going into effect. But it's about the beginning and the end of tenancies. So as the landlord, you want to make sure that you're actually taking photographs of the unit before the tenant occupies it. So there is a photographic record of the condition of the unit, and then same when the tenant vacates. So that will be very helpful for you as the landlord, just to have that documentation. Next law, AB 2347, went into effect January 1st, and it actually extends that deadline for eviction court case filing so that a tenant has 10 days to provide an answer to the court for any unlawful detainer lawsuit. So this increases their response time from 10 days to from 5 days to 10 days. So they now have 10 days. Also, going into effect January 1st, 2025, AB 2747, and that's rent reporting. So the landlord offers the tenant the option to report one-time rent payments to credit bureaus. And the landlord can pass through a cost of up to $10, but they should only charge the actual cost. If it's less than $10, we do have this included in our regulations, just to clarify that if your tenant requests this service, that you can pass through that $10 fee and it's not considered part of rent. And then, you know, if they don't want to do that anymore, you just take that $10 fee away and doesn't affect your rent at all. All right, SB 611 bans junk fees. So just limits certain types of fees that some landlords were charging. So no extra fees, like for accepting personal checks or return of fees type of charges. So just be careful about any kind of junk fees that are unrelated to the actual payment of rent. And then the last one that we'll look at for now is SB 1051 that also passed January of this year, and that just sort of adds in additional domestic violence protections, where stating that a landlord has to change the locks for a tenant at the landlord's own expense within 24 hours of them being provided information that a tenant or a member of that household has been a victim of abuse or violence. Alrighty, so that is sort of the end of the main presentation, and now we'll just go over, you know, where you can come and get some additional help. So for our landlords, we have a housing help center that we are currently running every Thursday. It's actually every Thursday, not every first and third Thursday. We've extended it, especially because of the utility petition. So if people needed extra help, we wanted to make ourselves extra available. So we're actually here every Thursday from 1 to 3. This webinar is sort of part of this educational outreach series. So you can come join us virtually, or if you want to come to our office, we're at 298 Escuela Avenue, right next to the Senior Center. We also have a separate housing help center for tenants. So this is a good resource for your tenant if you want to pass along the information and maybe have them come get help for rental assistance or anything like that, they can come to our office every first and third Thursday from 6 to 8. They can also join virtually as well. And finally, let's look at the upcoming July workshop. So we have a workshop on July 8th. That's a Tuesday at 2 p.m. And we'll talk about how to lawfully increase rent. So that gives you sort of just enough time to get ready, to get your notices ready. So you have those 30 days before the new rent increase is in effect in September. And there's also a webinar on July 17th at 2 p.m. That is another Thursday. So that will be talking about submitting the utility adjustment petition. So that will be going into a lot more detail about what the requirements are and how that works. So you can register for these online. They're both virtual only. All right, then last but definitely not least, you can reach out to us directly by phone, by email, or you can come visit our office between 9 to 5, Monday through Friday. And we also have virtual office hours every single Tuesday through Zoom from 10 a.m. to 12 p.m. at mountainview.gov/RSP office hours. And then if anybody needs additional language assistance, we have in-office Spanish speakers, and we can get any other type of language upon request. So just let us know. All right, so that is the end of the presentation. Please do not hesitate to reach out with us if you have any questions, and we hope to hear from you soon. All right, thanks for coming. Bye.